Imagine somebody just gave you a dirty slap and you turn to see the person is dressed shabbily. Or somebody did something terribly to you while you are trying to react. Somebody touched you and said, the person is insane. I remain Ishaku Joseph Shirima, your favorite lawyer, bringing you teachings every day. We have taken some series on the defenses available to an accused person, and today we are taking the defense of insanity. It's a common scenario that we have seen every day in the society happening. And most times when you want to react and then you realize that the person is mentally derailed, the person is not in control of his senses, no matter how painful that thing he has done to you, the normal situation, the normal occurrence most times is that people tend to behave and let go. Because imagine you fighting with a mad person. Will it make sense? We all know that a person cannot be liable for his act when he is incapable of understanding what he did. If a person behaves in a behavior from his angle of mental retardation, a psychiatric patient cannot understand what he is doing. And so the provision in law is that a person cannot be liable for his act or omission when at the time he committed that act or omission, he is not in full control of his senses. He cannot comprehend what he did, so there cannot be intention, there cannot be calculated attempt to perpetrate what he has committed because of lack of senses or because of the psychiatric case he is going through. Now, this defense is very important for us to understand and to take note of it, because it is good for the accused and it is also good for the victims of the accused. It also applies in civil liability. When you are trying to engage in any form of contract or an agreement or any form of transaction and you realize that the person is not in his senses, even if you try to take advantage of such person, the liability of that contractual relationship cannot be binding on him once it is established that the person was not in control of his senses at the time he enters this transaction. Now, generally in criminal cases, what is the essence of punishment? The essence of punishment is for correction, retribution, and all that, which cannot apply to a person suffering mental health. So the thing is, if a person is able to prove, most times will prove through relations, through your counsel, that the commission of this offense, at the time the accused committed, the accused is not in control of his senses, then that will be a full defense to exonerate him from liability, because the law will exonerate him from being liable for an action he committed at the time that he is not in control of his senses. I hope you understand this defense, and then it can avail anybody who needs it and anybody who truly acted in a position at the time when he is not able to take control of himself. That is all about this defense, and then follow us for the other defenses that are available as we keep bringing them to you line after line, so that you understand and know which one avails anybody around you or yourself. Thank you very much. Make sure you follow on our next video. Please, if this is your first time of seeing our video, kindly subscribe to our channel, follow our channel, like our videos, and share to other people so that they'll be able to see and learn the things you're learning. Thank you so much. We'll see you in our next video.